Seeing my shared screen, Gail?
Yes.
Yeah, good.
Okay. So we'll go ahead and get started. We have about 75 people online so far, so we'll go ahead and get started. So good morning, everybody. Welcome to the 2021 OSP Roundtable. So I'm Gail Fagan. I'm the Program Manager for Research Development and the manager of the monthly OSP Roundtables. Before we get started, just a couple of housekeeping items. So please remember that these presentations are recorded and posted on the website for public access. Therefore, we ask that you turn off your camera and mute yourself. And if you have any questions during the presentation, please use the chat or raise your hand function. I do have a list of everyone who has sent me an email so far for RACP credit. If you haven't done so already, please send me an email by the end of today so I can get those to Jocelyn. And then finally, should you have any suggestions for future presentations, please email them to me. And on to today's presentation about intellectual property management of sponsored projects with Columbia Warren. And Columbia, I'll go ahead and let you take the floor and introduce yourself. And
thank you, Gail.
Sure.
This is being recorded, so my pandemic cut can be kept for public. Always good. Good morning, everyone. Yes, this is IP Management Roundtable. I am so glad you could all join from all your various places. It's pretty amazing what we can do. Our household is currently under quarantine, so I wouldn't be able to really leave the house, but we can have this Zoom presentation just fine. As Gail said, I'm Columbia Warren. I'm a senior GCO on the federal team. And most relevant for this presentation, I deal with what we call university flow-through. So I see funding that comes from miscellaneous sources, including foreign universities, New York and other states, foreign governments, foundations, nonprofits, various companies and consortia. So I sort of am at the nexus of a lot of different IP situations that come through to Cornell. I certainly don't hold myself out as an IP expert. Nobody has all the answers about IP, so we really work together as a team. We consult with one another a lot. For that reason, I'm being joined by a lot of other associates at OSP today. Tom Goodness is the team lead on the nonprofit and foundation team. He's very experienced in intellectual property. I believe we have some people from CTL. I invited Martin Teschel. I hope he's available for questions. So we want to address intellectual property at Cornell because it is, IP is a complicated topic. It can feel a bit overwhelming sometimes, but we're all working together. It's a team effort to make things work smoothly here at Cornell. We consult with one another, and we're hoping that this sort of presentation can bring many of you into the fold in the team effort to have IP management work smoothly at Cornell. So let's see, can I click on this? Yes. So for the purposes of introducing IP and how it works at Cornell, we're going to first go over the basics of IP, probably a review for many of you. It is vastly complicated, but we'll just go over a few things. Then we'll cover Cornell policies that are relevant for IP at Cornell. And then I'd like to go through sort of the life cycle of a sponsored project at Cornell and where issues lie for IP. Starting with the proposal, that definitely, even prior to the proposal, there are considerations to be taken. Going over the proposal and then on to awarding and dealing with negotiating awards, managing awards, dealing with IP that comes out of awards in disclosures to CTL and how CTL would manage it. And then I'd like to cover a few various topics, one called the Gateway to Partnership Program for commercial entities, and then some other topics. I should note, I know I have an acronym there. CTL is Center for Technology Licensing, which many of you probably know. And of course, I welcome questions and comments from the peanut gallery of my associates out there, if anybody would like to add anything. Does anybody have any questions at this point? I have to laugh. I keep looking at the word miscellaneous, and just recently I mentioned that to my daughter. I said miscellaneous, and she looked at me and said, "Daddy, it sounds like you're just making up words." It is a kind of a strange word. She's 7 years old. So first, just the basics of IP. IP, intellectual property, is the legal right to determine who can use a product of creativity. It protects creators and gives them some value in what they've done. Generally, the creator is the first owner of the IP by legal right. And that can, of course, be transferred, and the rights can be transferred along with rights to commercialize, rights to use in many different forms. In general, I should say pretty much across the board at Cornell, we're talking about licensing when we talk about Cornell transferring rights to intellectual property. So as many of you know, I'm sure there are 4 categories of intellectual property, 2 of which are really the most relevant for working with intellectual property at Cornell. That, of course, is patents primarily, and then secondarily copyrights. The other 2 categories are trademarks, which are generally not relevant, though they may become relevant when something is being marketed or has later uses. And then, of course, there's trade secrets, which is sort of the odd one. It is not protected in the same way as the others. It is protected by keeping it a secret. And that's generally also not relevant for sponsored projects, but it can become an issue when we're dealing with companies that try to assert great control over their trade secrets and try to assert sort of an overreaching control over what Cornell ends up doing. So just to talk about patents a little bit, patents are the right to determine who can make, use, or sell an invention. Plenty of inventions come out of Cornell work. And an invention is a new and useful material, device, or process. To protect an invention through a patent, there has to be a patent application to the US Patent and Trademark Office. At Cornell, that would be done by CTL. And one thing of particular to note, anybody who is involved with an invention or has any connection with it, it's important to know that public disclosure can drastically affect the ability to protect or patent an invention. There's some leeway in the US. There's a 1-year time frame, but that still you don't really want to publicize before you have secured some protection. And then in other countries, I believe any public disclosure will definitely is fatal to patent protection. So just to give you some examples of what varieties or what patents could be, particular for Cornell, plant varieties and rootstock is a very common thing. There's a lot coming out of the agriculture sector. Just a few others. This is not at all an exhaustive list, but there are textile materials, chemical compounds, hardware, computer hardware, signal processing, AI related things, and some software is patentable. That's a rather arcane area of determination. I did a little research, and the first thing I found used the phrase, "it depends," one of our favorite phrases. So that's, of course, if you're dealing with software, and that would be something you would consult with CTL about. Moving on to copyright. certainly plenty of copyrightable material comes out of sponsored projects. Copyright is the right to determine who can reproduce or modify text, art, or music. In the US, copyright protection is automatic, though to actually pursue litigation related to it, you do have to register. As I mentioned before, some software could be patented, but a lot of software could fall under copyright. There are, as I said, plenty of complexities to that. And copyright provided a citation there or a link there for any other copyright, many other copyright issues that may be faced. Some art, these are some examples, articles, books, blog posts, manuals, drawings, songs, most software, many other things, anything that is creative media in a fixed form. I was sort of intrigued to find that recipes can't be copyrighted because you can't copyright an idea. And it is basically considered listing simple ingredients, and if you list simple steps to put it together, that is copyrightable. So I just wanted to provide the policy statement and the reason for the policy of inventions in the Cornell policy, which sort of succinctly tells how it operates at Cornell. All Cornell employees and any individuals using Cornell resources have to assign their rights, title, and interest in inventions to the university. That is to say, anything using Cornell resources and any Cornell employee operating or working under their appointment, all of that IP, all of those inventions are Cornell's and Cornell's to control. So to summarize, it's all owned by Cornell unless it is created or developed outside the duties of employment, and it is not using Cornell resources. Again, that's touching on, there may be non-Cornell employees that use Cornell resources, and they are supposed to assign their rights to Cornell. And of course, part of the policy is any inventions need to be disclosed to CTL, because CTL is the focal point for managing Cornell's intellectual property. And this is where the rubber meets the road for a lot of inventors. This is the trade-off for Cornell owning inventions that are invented by employees. There's a distribution laid out here, gets a little odd. 1/3 to the university, 1/3 split in the way written there, and 1/3 to CTL for operational costs. This is the distribution for net revenues for any activity, any licensing generally for inventions of Cornell's. Any questions at this point? It's funny to look at all these blank screens. I hope you're all there. So the Cornell policy on copyrights is a little convoluted, and oh, do I see a question? Ah, I do not. The Cornell policy on copyrights is a little convoluted. There's a little bit of a rabbit hole that you could go down. The succinct statement is faculty members own the copyrights in their scholarly publications. A lot of what comes out of, from faculty members is owned by those faculty members. Does not involve Cornell at all, does not involve CTL. However, the university does get involved with copyrights and own copyrights for work for hire, that's general across the board. If you're an employee and you produce an article at the direction of Cornell, that is Cornell's copyrighted property. Or using substantial use of university resources, which includes grant funding, external funding to Cornell. So there's a little bit of a circular situation there. Scholarly works that are created under externally funded projects, I would say they're in a little bit of a gray area. They may technically be owned by Cornell, but they are not generally something that Cornell needs to be involved with managing. So that is to the second point here. Scholarly works should be disclosed to CTL only when they intend to broadly distribute their work or commercialize the work and or the copyright subsisting therewith. Authors should also disclose their work to CTL if they believe the work and the copyright subsisting therein are of great value to the university. So not a lot needs to get disclosed to CTL when it comes to copyrightable materials. What does need to be done is if there's really any value to it, or if it is potentially going to be commercialized or broadly distributed, then it is called for at least contact CTL and discuss this to see what steps should be taken. So I wanted to move on to really what all of you should be aware of. You know, when you come into contact with sponsored activities, IP is always an issue. IP is always something to be on the lookout for. And really, the roles of most of us are issue spotting. Figure out when we see something that's an issue, when we need to reach out to OSP, reach out to CTL, and you know, consult with us, gather more information, and see what next steps should be taken. When it comes to proposals, this is one of many reasons why proposals should go through OSP. Proposals and you know, working on awards without OSP is it happens a fair bit in different areas with different sponsors. Commercial entities, certainly a concern, which happens to overlap with commercial entities, are also where the most concern related to IP is. So in any way that OSP can be brought in, excuse me, to work with the PI and the sponsor early on, dealing with IP, especially with commercial entities, is really valuable and can really make things run more smoothly. I also encounter quite a bit issues with foreign governments. Quite a few foreign governments do not have the same intellectual property scheme that the US federal government does. Some federal governments, or some foreign governments, really want to own IP that comes out of anything. Others have a little bit looser regulations that require that the IP be used to benefit that country. Those can sometimes be worked around. I've been in some situations. We looked into doing some work with some Japanese agencies, and there's just no getting around that they were going to own the IP. So that did not really proceed. A couple other entities that I come across quite often, the Australian Research Council, also the Qatar National Research Fund, both have issues to differing degrees that relate to IP. So if we can know about that in advance and discuss it and consult with the PI, all the better for it. Some other sponsors, federal and state commercial contracts, and foundations and nonprofits can also be issues, generally to a lesser extent. So a couple things that may need to be done at proposal stage: background IP and disclosing background IP, even deciding whether a project should involve background IP or should go in some other direction can be an important thing. So background IP is intellectual property that already exists and would be brought in to be used in a project. Quite in many respects, it needs to be disclosed when you're doing a proposal. Sponsors want to know about that if it's relevant. And it's of particular concern if it would be a critical element of the results of the project. This is in the case of a sponsor that may be trying to get a license or to be able to use this, the results of the project, knowing that there's additional intellectual property that could block their usage is pretty critical. And of course, just in general, we want to be able to review terms if they're being provided to us up front, review the sample agreement, and if there are terms that are problematic, we would provide exceptions to that. So hopefully an award comes in and we have an award to review and negotiate. So we would, of course, review, when it comes to intellectual property, we would review those terms. We could get into a very deep dive and go into the very wide range of permutations of different intellectual property terms that could probably be reserved for a day-long seminar at some other time. But in general, we can say federal assistance agreements are under the Bayh-Dole Act, which provides IP ownership to the nonprofit institution, to Cornell, for intellectual property that arises out of a project. The federal government reserves certain rights. So I bring that up, of course, because that's sort of the default. That is what a lot of our funding is under. That's perfectly acceptable, no issues. We continue on with that. Beyond that, it's a wide range from also perfectly acceptable to not at all acceptable. And so our analysis at award stage reviews all of that. So other issues that may, steps that may need to be taken at this stage are disclosing background IP if it hasn't previously been done. Working through that, negotiating the terms. And then, so if the terms are not outright acceptable but they can be accepted, we will need to do what is called, colloquially called an IP waiver. It is really the acknowledgement of waiver of rights under Inventions and Related Property Rights Policy 1.5, what we call the IP waiver. So this is, if we get to the stage where we have terms, we have worked with CTL, we've worked with others, we've worked with the PI, we've negotiated with the sponsor, and we have terms that are can be agreed to, but differ from our standard terms and differ from the default in the policy. Then we need to secure an IP waiver, which is an approval and acknowledgement by various parties. So we have two sets. This is more of a background that doesn't really need to involve most people. We have a set of pre-approved terms that have been approved by the Office of the Vice President for Research and Innovation. That's the new term for the OVPR. We have a set of specific terms from specific sponsors that have been reviewed and approved, and we can proceed. We proceed in a certain process I'll go over in a moment. And then there are some categories of terms that have been deemed acceptable. The specific language hasn't necessarily been reviewed, but they are a category of terms. Generally, they are allowing, they're for a public purpose. They support what Cornell supports. Cornell may be relinquishing some possibility of revenue from it, but it is generally for a public purpose. And then there's the wide variety of terms that have not previously been approved, and we need to work through a full approval process for that. So here's the IP waiver process. This is a process that the GCO initiates and controls and takes the lead on. This is, of course, if the GCO has worked with CTL and the PI and everyone and basically agreed in principle that these terms seem acceptable. We need to hold the agreement, signing the agreement until the IP waiver is fully signed. It needs to go through to the last signature before we can sign. So there can sometimes feel like there's a bit of a time pressure to get this in place quickly. So as I mentioned, with those pre-approved terms, the approval process is a little bit shortened because the Vice President for Research and Innovation has already approved these. The GCO would draft the waiver, send it to the PI or the department, whoever's been the contact, have that IP waiver circulated for these various signatures, PI, co-PI. Want to note there, key personnel. We have that, we call it key personnel, but that's really anybody on the project who could provide intellectual input to the extent that they could be an inventor on something. So that would most often also include grad students, certainly postdocs, anybody else, possibly even, you know, if they're technicians or research associates, anybody who could be considered, you know, somebody putting intellectual input into the project. And then, of course, the chair and the dean. Then we would want the signed waiver returned to the GCO, and then that would go to our OSP director for signature. In the situation of terms that are not already pre-approved, it's the same process, though it tends to require a lot more review at the outset. We consult with CTL further, the Vice President for Research and Innovation, Emmanuel, and counsel if necessary, and then go through the same process, and it ends up with a signature by the Vice President for Research and Innovation. A very important point that has been missed in the past and has caused issues and problems. This is the IP waiver is sort of a living document. It needs to be updated as individuals come on to the project. Any grad students that come on, any different researchers, they need to be brought in and they need to sign this waiver when they are appointed to the project. It's really critical because this is we have committed to an outside sponsor to certain terms, and the participants on the project need to acknowledge these terms and be aware that this is the scheme that they are working under. Does anybody have any questions about anything, particularly the IP waiver process? This can get a little confusing. Absolutely clear to everyone. Very good, very good. So just want to touch on working with CTL briefly. To a certain extent, CTL is a bit of a black box, at least to me and some others. You know, a lot of work goes on in there, but it's a bit outside of my view, at least. So as I mentioned before, disclosure to CTL of any inventions is required by Cornell policy. It's also implicated most sponsored projects require that any inventions be disclosed to the sponsor, and that would all be handled by CTL. So that is, again, CTL is the focal point for that. They manage intellectual property at Cornell, so anything relevant should be disclosed to them. And again, working with CTL as soon as possible when something arises or is tangible in some way is definitely an important point to allow for protection and you know, just to cover our bases for everything. And of course, once it is, oh, sorry, we have a question. question is, how can research administrators know when an IP waiver has been associated with a project? Is there a notation in RAS? There is a notation. I'm trying to figure out if it's a notation or if it's just in the workflow. It is definitely visible in RAS that there is an IP waiver. We've gone back and forth a bit with where the actual IP waiver would be held. And I actually can't recall at the moment whether we are putting them into RAS or not. But definitely there is, it is evident in RAS that there is an IP waiver in place. Yeah, it's a good question. So as I noted, CTL, the disclosure goes to CTL, and they will work with the inventor, work through the next steps, whatever it may be. I don't know how many disclosures get to patented materials. It's not that many, but lots of work goes into patenting those that are worthy of that. So we're sort of moving on to the miscellaneous categories, but this is a program, the Gateway to Partnership program, which has been developed. I know a lot of effort went into this, getting some standardized terms. This is all about working with companies, standardizing what is available to companies, and at various levels of funding and various levels of strategic importance, strategic connection with Cornell. There are a set of off-the-shelf terms that can be offered to companies. This is most relevant for those PIs who are starting the process with companies, working with companies. This is an available resource. There's a link there to learn more about this. This is intended to streamline and provide a bit more certainty in the process for everyone. There's a long background of issues arising and negotiations taking plenty of time, too long to get these things nailed down. So this is an opportunity to streamline that. There are, so we're sort of, I'm down to the last issues to be spotting, and there are plenty of them. This is all about keeping things on your radar, trying to keep track of where problems may arise. As I noted, there are issues with non-Cornell employees using Cornell resources. This can be visitors, all sorts of collaborators, students. They should be assigning to Cornell intellectual property if they are using Cornell resources. That is to say, there should be some sort of agreement in place, and there are different sets of assignment forms that can be used for different people, and that should be looked into if we have a visitor or collaborator of some sort. There's also a rising, especially in the New York Tech campus, there are a lot of projects, student projects that are coming up, receiving some funding from external sponsors. And the terms do not really align with how Cornell associates should be dealing with IP. A lot of these, a sponsor will provide a little bit of funding and then assert control over the IP that arises, ownership of the IP. I know there are ongoing efforts to try to shore that up. And if you're in that scenario, in that situation, please reach out to OSP and we will work on that. So another issue that arises is, and this is actually noted in the IP waiver, the IP waiver cautions to not commingle funds among projects that have restrictive IP terms. That would lead to conflicting IP situations and just would be a mess. Generally, if there are agreements or funding arrangements you're working under that have these terms, you need to silo people, silo funding, silo work, so that there's no crossover between different projects. Another thing that certainly arises on a regular basis is faculty that have outside companies or other situations. I think it's generally companies, startup companies, where there's expectations or misunderstandings about what rights they may have in the IP they created that is owned by Cornell, or other scenarios like that. That is a situation to be very aware of. Bring CTL and OSP in if that's something you see. The last thing I wanted to point out is there are plenty of issues that can arise with faculty that are transferring in, transferring out, that have portfolios of intellectual property. That can, of course, create conflicts when you're looking at projects that use that background intellectual property. You may have different institutions that control the intellectual property. It can cause headaches and cause a bit of a mess. So it's another reason that OSP should be involved very intimately in transfer situations, both in and out. See, okay. Any other questions? Okay, I am getting questions online. Would anybody like to verbally ask a question? I've been told that there are, generally the IP terms are noted in RAS, and we think we are uploading the waivers. We need to get back on that.
I'll throw you a line, Columbia, and ask my question out loud.
Okay, yes, it's hard to read through questions as I'm talking.
Sure. So this is Liz at CALS, and my question is, in addition to these miscellaneous issues that you outline, which are really great refresher, when you're reading an RFP or a faculty member forwards you some other documentation from a sponsor, like a draft contract or anything, what should we be looking out for? What are there yellow or red flags that people just generally can watch out for when they receive materials that will ultimately end up with you for review?
Yeah, I mean, obviously the big one is the ownership of the IP going to the sponsor. Sometimes it's stated in that way. I guess another way of putting it is that Cornell is doing work for hire. That's probably should have noted that as something I've written out. But if you ever see work for hire, that is definitely I'd call that a red flag. If there are any proposed licensing terms or anything where they are trying to pre-state how allocation would occur, sort of a yellow flag, I would think. One other issue, and I had sort of alluded to this with trade secrets, is control over releasing the results or publishing the results. That's of course an issue from a publication standpoint and those things, and but it can kind of cross over into intellectual property. So if there's any sorts of those issues, that's a red flag in many ways. Can't think of any others right off the top of my head. If there's anybody in the peanut gallery who has more experience, possibly with commercial contracts, if anybody can think of anything else, let me know. Do have one lengthy, let's see. I have a lengthy question that I think I will follow up with on directly. There are many permutations and lots of it depends when it comes to dealing with IP. You know, I can say as a bright line rule, as far as a bright line rule as we can get, as close to a bright line rule, is that Cornell will not do work where we're relinquishing ownership of the intellectual property. Now, there are certain types of agreements where we actually, they're routine product testing agreements, a few areas where we are doing work that is not really within the research realm, where we are doing work for hire. And the lines can get blurred there as to what type of work we're doing. But in a general research context, Cornell will not relinquish ownership of intellectual property. Beyond that, there is some room for negotiation.
This is Martin, Columbia.
Yes.
If I may, I might actually add to this that not only ownership, it's also the control of the IP, right? We typically would be very reluctant to give up at the outset, right? So
yeah,
especially in situations where we're committing some kinds of first mover rights to a sponsor, we would still want to retain the ability to control and make decisions, especially when it comes to filing patent applications. So because for us as CTL, this would effectively amount to an sort of an unfunded obligation, right? So on the one hand, we're giving away some rights to the IP already while we're still more or less obligated to spend Cornell's money on patent protection, that sort of thing, right? We've also seen it sometimes in collaborative agreements where even between institutions, oftentimes this comes up with foreign institutions or even visitors, right? Where there's some kind of agreement put in place, then where the other side wants Cornell to commit to a certain sharing arrangement of IP, and including how to spend money on patents, right? So this is something we have seen before, and unfortunately agreements like that have been signed before, and then CTL finds itself in a situation we have no choice but going along with the other institution, right? As far as filing patent applications and even sharing the cost of it, even though we might not have a whole lot of control over what happens with the IP, right? Those are examples, but in general, I would say not only the ownership, but it's also the control of the IP.
Yeah.
IP protection.
Certainly, when we're in that, when it is crunch time and we're coming down to, you know, negotiations in that realm, CTL is heavily involved in making decisions about what they can commit to, you know, what, you know, how that would be managed. Yeah.
Columbia.
Yes.
Regarding ownership too, I think we have a little more flexibility with copyright than we do with patents. So that's some IP we have flexibility with, and that's copyright. In the policy, there's some, you know, term about who owns it, and there's a phrase about like requirements of the contract, and that's been interpreted so that we can actually grant ownership to a sponsor, but in that case we typically reserve like a lot of rights to use it academically.
Yeah.
So for example, like a manual that we might produce for this, the highway department of New York State. They might insist on ownership of that, and we can say, okay, but we reserve like rights to use it for our research and educational purposes.
Yeah, yeah. Yeah, of course, copyright is one of those things. It does involve Cornell, and Cornell has lots of rights and control over it. Though, of course, copyright is generally not a very revenue generating aspect. So it tends to get, it tends to be a lot more flexible in that realm, certainly. All right. So, final call for questions, I suppose. I know there are plenty of very situation-specific questions that arise. As I said, it's very complicated. There really are, I tried to state a bright line rule, and of course there isn't quite, there's even vagaries to that. But if you have any questions, there are lots of people to reach out to. The people on the appropriate team, CTL, lots of people who are available. And of course, if we don't know, there's plenty, again, that many of us don't know. We reach out to others who are more familiar.
All right. Thank you, Columbia.
Thank you.
And it doesn't look like we have any more questions. So with that, we'll give everybody back 10 minutes to their day. And then next month, February Roundtable will be a RAS update. So we'll hear from Carrie and Chris Ashdown some new changes that are coming, that have happened to RAS and then coming up as well. So again, if you need RACP credit, send me an email. And if you have any suggestions for future roundtables, send me an email as well. All right. Thanks, everybody. Have a great day. Bye.